Explosive claims today from a man said to be the best-known criminal lawyer in the world. Alan Dershowitz railing against the prosecution, the second-degree murder charge against George Zimmerman, the Neighborhood Watch volunteer, who is now charged in connection with the death of Trayvon Martin. Mr. Dershowitz is a Harvard law professor who has argued nearly a dozen cases before the U.S. Supreme Court. He is the man who successfully got the conviction of Klaus von Bülow overturned, among many, many other famous cases. And now he is here with me on the set. Professor Dershowitz, it's an honor to meet you in person.
My pleasure.
And you are now saying that if anybody should be criminally charged in this case, it is the prosecutors. Why?
Well, first of all, anybody who is involved in a shooting should be investigated, and perhaps there should be charges against Zimmerman. So let's put that aside for a second. But this affidavit submitted by the prosecutor in the Florida case is a crime. If she, in fact, knew about ABC News's pictures of the bloody head of Zimmerman and failed to include that in the affidavit, this affidavit is not the truth, the whole truth, and nothing but the truth.
Why do they have to put in there? Why do they have to, and there's the picture. Why do they have to put in there the evidence that is bad for their side?
Because they're prosecutors, and prosecutors, when they submit affidavits, have to tell the whole truth, not just a partial truth. A half lie is a lie. And by suggesting that, as they do in this, Zimmerman confronted Martin and a struggle ensued, the passive voice, without describing the fact that there is evidence that during the struggle, Martin may have been on top, Zimmerman on bottom, and the bloody head may have been caused, according to Zimmerman, by the banging of his head against the ground. You can't leave that kind of evidence out when you're seeking to indict or inform against somebody. That's a half-truth.
Just educate the viewers, because I think most of our viewers assume that, you've got the prosecution, they have one agenda, you've got the defense attorneys, they have a different agenda. That's not necessarily true. The prosecution has a different goal.
Prosecution's job is to present the truth and the whole truth. It has obligations under the law not to suppress evidence, not to hide exculpatory evidence, and to seek justice. Not to seek justice for Trayvon or for Zimmerman, but to seek justice for the entire society. That's their job, to make sure that there is a just result. Now, I've heard from some, well, the prosecution has more evidence, but they're holding it back. This isn't poker, where you hold two cards and you flip them later. This is the justice system. And the justice system has to be resolved by our usual procedures. Better 10 guilty go free than 1 innocent be wrongly confined, proof beyond a reasonable doubt, and all the evidence of innocence must be set out by the prosecution. The United States Supreme Court has said that repeatedly.
But they will. They'll do it at trial. They have to do it in the probable cause affidavit.
Too late. You don't indict based on false information. Now, one of the problems is because they've indicted for second-degree murder, and there's nothing in this affidavit that suggests second-degree murder, the elements of second-degree murder aren't here, the expectations have been reduced. There was an article today in one of the Daily Beasts saying there'll be riots on the street if there's an acquittal. If there are riots, it will be the prosecutor's fault, because she overcharged, raised expectations. No reasonable jury is going to convict based on the evidence I know of second-degree murder. So this prosecutor not only may have suborned perjury, she may be responsible, if there are going to be riots here, for raising expectations to unreasonable levels.
Do you think, she went down there to Florida, or she's in Florida, but she went out and when she announced these second-degree murder charges said, we are here to seek justice for Trayvon, That raised a lot of eyebrows because is it justice for Trayvon, or is it just justice?
It's just justice.
Because Zimmerman is claiming that it was self-defense, that he was the victim in this,
this is not the first time this speech has been made. It was also made in the Anthony case, where the prosecutor said, we need justice for Kaylee. And the jury said, no, you need justice for the defendant. There's only one person on trial, and that is the defendant, George Zimmerman.
But
only
Kaylee,
one person who has
different
rights.
Because Kaylee, you knew Kaylee Anthony was a genuine victim.
Right.
There was no question. Trayvon Martin appears to be a victim, but we don't know. Zimmerman's whole defense is that he was the victim.
Look, they may both be victims. Trayvon Martin was a victim. He was not committing any crime. He was carrying Skittles. He shouldn't have been followed. He shouldn't have been confronted. But if, in fact, Zimmerman is telling the truth, that he was blindsided, that Martin turned from a victim into an assailant, you may have two victims, two provokers, and a very complicated legal issue that always must be resolved in favor of the defendant. When in doubt, you always resolve those doubts in favor of the defendant.
But I want to ask you, because this is one of the questions I've been asking all along. Can you get to second degree if you can prove Zimmerman stalked Trayvon? Zimmerman had no right to do that. Zimmerman ascribed criminal motives to him that were not appropriate.
Absolutely not.
Zimmerman then abandoned pursuit, but was confronted by Trayvon. But the only reason he was confronted by him and forced to engage in self-defense was because he was the initial aggressor in stalking, following, etc.
No, the statute's very clear. If you're the provocateur, let's assume under your hypothetical that Zimmerman was the provocateur, you lose the stand your ground statute, but you don't lose traditional self-defense.
So even if he can argue in front of a jury, but it's not going to get him out of the criminal trial altogether.
Well, it might. It might get him out of the criminal trial because the stand your ground statute gives the judge the right under the general statute to look at the law. Any reasonable judge should throw out second-degree murder. And now we're down to manslaughter. Then you have to ask yourself, is there enough of manslaughter? Not in this affidavit. There may be more evidence that the prosecution now has. But my great fear is that the prosecutor has raised the stakes, has raised expectations, and she may be responsible for whatever the results are if there are going to be an acquittal, which I suspect there will be in this case.
Why did she do that?
Because she's a politically elected person who was appointed to get Zimmerman. She was appointed to prevent riots. She wasn't appointed to do justice. She was appointed to calm the situation down. That's the problem when you elect prosecutors. We're the only country in the Western world that elects prosecutors. Prosecutors run for re-election based on how many people they put in jail. That doesn't produce justice.
We saw that problem. I'm not saying it applies here, but we saw that problem in the Duke fake rape case with Mike Nifong, who was running for re-election.
And look what happened to him. He went to jail for a night and got disbarred. If I were this prosecutor, I'd be hiring a lawyer at this point.
Wow. Alan Dershowitz, thank you, sir.
Thank you.
Pleasure to meet you.
My pleasure.
Taking your thoughts on it right now. Follow me on Twitter, @Megyn Kelly.